Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. Get your ass in the chair.
For what?
For contempt of court.
I haven't.
You can appeal that too. Sentence is 30 days. See you in 30 days.
I'm on behalf of the people, P86771.
The judge needs to address you, sir. Is that a problem, sir?
Yeah. You're a defendant. Sit at the defendant's chair.
I'm not a defendant. I'm sorry, officer.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen. And
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
Maybe I'm not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion, but there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to...
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
And if I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on record?
Yes.
Are you going to be oath to the Constitution?
Hold on. What, are you picking him up? That's one of the reasons I want you up here, so there's a microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oath to the Constitution.
You haven't.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding your oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have...
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'll present myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceedings?
I will be presenting myself today.
may
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay. All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record. I'm fine.
Okay.
So, with that being said...
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So, today...
You have a jurisdictional argument you want to make?
Well, I've served notice...
Sir, it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a...
Yes or no?
Why are you forcing me to say...
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that...
I work under the authority of the state of Michigan.
What is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know...
This is not admiralty.
What is
And
it?
it's not common law. It's statutory.
Okay, so it's statutory. That is what? Civil?
No.
So what is it?
My jurisdiction is both civil...
I can't defend myself unless I have it on the record. Is it?
My jurisdiction...
It's only two...
Sure, shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is...
This is a criminal case.
Okay, right. So is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
All right, so if the people of the state of Michigan, right, where's the sworn statement
Where's what?
A sworn statement. I have a right to see a sworn statement saying I enter sworn.
There's a complaint in the file.
Sworn complaint, signed,
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan
How can I
are
injure the
bringing the
state?
charges.
How can I injure the
Sir,
state?
sit down. Sit
I'm saying,
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one.
I see.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
she's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name.
Your witness. Yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What I'm supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name?
No, you still out.
That's fine. Thank you. Witness.
Your Honor, the people called Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is okay. So right here,
This is the probable cause hearing.
it says
All right, stop. Right now, the question on the table is you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
to not waiving my probable cause hearing?
Denied. That's admitted.
Under what grounds have I denied not?
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid
I
objections
object
together.
that we are having a preliminary exam when I haven't had a probable cause hearing and I did not.
They're the same thing,
It's
Mr. Michaud.
still on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you ever had a grilled
If it
cheese?
was different,
Have you ever had a grilled cheese?
if it was different, why would it have two?
Have you
separate
ever had a
columns?
grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom. You want a PCC? Go out in the hall and have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Listen, you can't tell me something and then just disagree with me.
Well, okay.
Listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black roll. Okay? That's just the way it works. My courtroom, I get to decide how it's run. There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone
I
here
don't-
has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address. Okay, so
I'm not addressing any of that crap you
Can
got in
you-
front of you.
well, since you say you don't have a bond, can you express that in a via affidavit so I can have a?
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that I sent a affidavit of fee schedule for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice, and
Great. Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you
Okay.
said that.
Right, and
Move on.
you haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't
am
recognize
not
any of that.
United States citizen. I am
Stop.
actually
Hold on.
identified.
Stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent, or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does
And you
mean, hold
prove
on. It does, it should mean something.
Now the judge flips the script. The defendant demands proof that he's not an artificial person. But the judge points to the simplest fact of Ale, personally answered when his name was called. That's the moment the courtroom argument starts collapsing under its own logic.
Because prove it. Please prove
Can I
it.
prove what?
Prove that I am not that I am the artificial person.
I can prove you're Frank
I have
Michaud.
full faith and credit.
I can prove.
Okay, so
Hold on. You've asked me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And
you proved it for
threatened
me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean nothing. But
Okay.
you're still threatening me, and you're using it under color of law.
Okay, listen.
And plus,
Listen to me. Mr. Michaud.
You have more.
I've wasted too much time with you. Yes or
Okay.
no?
So-
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or
I
no?
object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days.